Can you restate that?
Objection, question calls for narrative.
May I respond, Your Honor?
Yeah, you may.
It's very pertinent to the members of the jury as Jesse Duran's actions are in question today. To receive a rational and fair basis as to the character of her.
Your Honor, may I respond?
You may, but real quick, remind the court what
The
the
question
was.
he asked was, can you please tell us a little bit about yourself? I merely asked that the opposing counsel narrow his line of questioning to be more specific to the case at hand today.
That's a fair point, counsel. Objection is granted. Perhaps you can restate the question.
Yes, Your Honor. Jesse, where do you live?
I live in Fairview, Midlands with my mom. It's just been me and her my whole life. And I've never really had a dad, but I like to think he's a war hero, and that's why I want to go into the military.
Jesse, do you know why you're here today?
Well, a few years ago when I was 11, my best friend Sydney, we were playing with a gun in our house, and there was an accident. And Sydney died.
Jesse, I do want to talk about that in a minute, but first, could you tell the members of the jury who Sydney was?
Sydney was my next door neighbor, but she was my best friend. I could talk to her about things I couldn't tell anyone else about. She was the first one I told I didn't have a dad, and she was really nice about it.
Jesse, how much time did you and Sydney spend together?
Well, since we were neighbors, we spent all the time together. We would walk to and from school together, and then once we got home, we would play at each other's houses. We were inseparable.
Jesse, why do you think you and Sydney got along so well together?
Well, at the time, we were both kind of tomboys, so we liked the same stuff, like action movies and sports, video games, and we were always playing in Sydney's yard with Nerf guns.
Jesse, earlier you said that there was an accident with a gun. Do you know whose gun you were playing with?
It was Sydney's parents, Mr. and Mrs. Park's gun.
How were you able to even get a hold of the gun, Jesse?
Well, Sydney had told me about it. She said it was in a safe and she knew where the combination was.
After she told you that, did you and Sydney go get the combination?
Yeah, it was in a filing cabinet in an office. I'm pretty sure they use it as a guest room sometimes.
So after you and Sydney got the combination, what did you do next?
We went to a safe and we unlocked it.
And once you unlocked the safe where the gun was, what did you see?
The gun was inside and there was also a box of bullets.
And once you saw the gun and the bullets inside this box, what happened next?
Well, we got the gun out.
And who loaded did anyone load the gun?
Well, we did it together. Sydney had opened the cylinder and I put one bullet in.
So after the gun was loaded, what did you and Sydney do?
We just went around posing with the gun. Sydney had it and she pointed at the wall and yelled, "Bang!" And then she gave it to me and then I pointed at the bathroom mirror. And then I gave it back to her and then she pointed it right at me. And that really freaked me out and I told her, "Sydney, that's not
Objection,
funny."
hearsay.
Response?
Your Honor, this would not be hearsay because the defense is not trying to prove that it was not funny that Sydney pointed the gun at her, which is why it would not fall under hearsay.
Okay, response?
Your Honor, I would say that any statement made by Jesse out of court today used for the truth of the matter asserted would be considered hearsay. However, if this statement isn't being offered for the truth, then it's simply not relevant to the fact of the matters at hand, whether or not Jesse intentionally meant to shoot Sydney.
May I respond, Your Honor?
No, I'm sorry, can you repeat that one more time? Any statement made by who?
Any statement made by Jesse out of court would still be considered hearsay. In addition to that, if it's not being offered for the truth of the matter asserted.
Okay, overruled, counsel.
Yes, Your Honor.
You may proceed.
Jesse, what happened once Sydney pointed the gun at you?
Well, like I said, I told her that it wasn't funny and by that time, I just wanted to go downstairs to watch TV.
So what happened once you and Sydney moved downstairs to watch TV?
Well, Sydney turned on the TV and she put on some cartoon that I know we've seen probably 1,000 times, and so I told her to change the channel. And she said to me, "No, this is my house." And so I was like, "Fine, then let me see the gun." And then she tossed it to me.
Jesse, what happened when Sydney threw the gun at you?
I just reached out to catch it, and when I did it, it went off, and Sydney fell to the ground, and she was bleeding.
Jesse, what happened after the gun went off?
I don't know. I don't remember anything.
Thank you, Jesse. At this time, there are no further questions, Your Honor.
Okay. Ross?
Yes, Your Honor. Good morning, Jess. I'm going to ask you a few questions this morning. Now, I'd like to talk to you about August 18th. On August 18th, you woke up a little early that day, right?
Yeah,
In fact, you were excited to see the gun, weren't you?
yeah, and I was pretty excited to go over to Sydney's too, but yeah.
Now, before coming to court today, you gave a deposition, right?
Yes,
In this deposition, you were asked several questions, weren't you?
yeah, they asked me a lot of questions.
Now, during this deposition, is it not true that you told the investigator that you didn't want to see the gun and that it was Sydney's idea?
At first, yeah, it was a pretty long time ago, so I was having trouble remembering.
So initially, you lied to the investigator.
Well, I was just confused. It was a pretty long time ago.
Yes or no, you told the investigator false information.
Well, I guess at first.
Now, I'd like to direct your attention to what happened after the Parks left the home. After the Parks left the home, you and Sydney went to the safe, correct?
Yeah.
And it was you who entered in the combination to open up the safe, correct?
Yeah, Sydney read me the combination and then I pressed the buttons.
And when you opened the safe, you saw a box of bullets and an A.D. Baker revolver.
Yeah.
Objection, Your Honor, to lack of personal knowledge.
Response point?
Your Honor, if the witness doesn't know, she can answer no, I don't know.
Response?
The question still calls for her to ask something that she doesn't know.
I'm going to overrule the objection. The witness can testify to what she knows and doesn't.
Yes, Your Honor.
I'll repeat the question. And when you opened the safe, you saw an A.D. Baker revolver and a box of bullets.
Well, yeah, the gun was in there with the bullets.
And the gun wasn't loaded when you first saw the gun, was it?
Not at first.
In fact, you yourself put the one bullet into the gun.
Yeah, but Sydney had opened the cylinder first.
Redirect me back to my question. You yourself put the bullet inside the gun.
Yeah, it was so dumb. I should have never done that, but I did.
Now, later that day, you two went down to the living room, didn't you?
Yes.
And it is there where you claim Sydney tossed you the gun.
Yes.
And you claim that you caught this gun with both hands, correct?
Yeah, I'm pretty sure. I just reached out to catch it. It was happening so fast, I didn't know what to do.
I just want to clarify for the members of the jury, you claim to have caught this gun with both of your hands.
I think so, yeah.
And after you caught the gun and the gun went off, you called your father, didn't you?
Well, I called my mom.
You,
Yeah.
you called your mother, I apologize.
Yeah.
And when you called your mother, you said the call lasted 20 seconds max.
Objection, Your Honor, to the relevance of this questioning.
Your Honor, I'm merely examining a point in the witness's testimony where she was untruthful.
I'm sorry.
There's a term directed.
Okay. Your objection was to relevance, right?
Yes,
Your
sir.
response was?
That this will show an instance of untruthfulness, and truth is always relevant.
Okay. Is your response to that?
It doesn't make, or it doesn't tend to prove any fact in today's case, whether, how long the call actually was on the phone to her mother.
I'll allow the testimony. Go ahead.
Yes, Your Honor. I'll repeat the question. You said that the call was 20 seconds max.
I think so. Like, it may have felt like 20 seconds.
But You would agree that if the call was 20 seconds maximum, and that's what you told the investigating officer.
I think so. I guess that's what it felt like. It felt like a really short phone call.
Now, I'd like to show you, for the record reflect, I am approaching opposing counsel with the call information for contacting on this Voldemort.
No objections to the authenticity, Your Honor?
May I approach the witness?
You may.
Let the record reflect I'm handing the witness the same document, Plaintiff Exhibit 4. Do you recognize this document?
Yeah.
This is a screenshot of the contact information for a contact in your phone known as Voldemort, correct?
Yeah.
This screenshot was taken on August 18, 2010, wasn't it?
That's what it says, yes.
And to the best of your knowledge, this is a fair and accurate representation of that call information for Voldemort.
It looks like it.
Now, to clarify for the ladies and gentlemen of the jury, Voldemort was your mother, wasn't she?
Yeah, at the time I was a huge Harry Potter fan and I thought it was funny.
And you can verify that the email and the phone number both belong to your mother, correct?
Yeah.
Now, on that piece of paper in front of you, there is a time for a call around 9:47, correct?
9:46, yeah.
9:46. And that call was made by you to the contact listed as Voldemort, correct?
Yes, I believe so.
And that call lasted 7
Objection, Your
minutes.
Honor, to hearsay and the fact that this document has not been entered into evidence.
I will respond. I will enter the document to evidence right now. And as to hearsay, this document is not hearsay.
Why is it not hearsay?
Because this document is not being made by any individual. This document is not, and this document has been authenticated as a phone record. This is not making a statement. This is merely identifying the length of a call.
Response defense?
Your Honor, the length of the call asserts that the time was 7 minutes, which is what the opposing counsel is attempting to assert, that that call actually lasted 7 minutes. Now, since it's being used for the truth of the matter asserted, this would be hearsay.
Your Honor, may I respond?
No, not necessary. To the extent that the document's not into evidence, counsel, please introduce it into evidence, but objections over the rest of hearsay.
Your Honor, this time I move Plaintiff 4 into evidence.
Great.
Yes, Your Honor.
Now, the call you made to Voldemort lasted 7 minutes, correct?
That's what it says, yes.
Permission to tender evidence to the jury.
Great.
Now, I'd like to talk to you about the games you like to play. You and Sydney would play these games that involve guns and violence, correct?
Sometimes, yeah.
I'd like to talk to you about some of these games. You played a game known as Normandy, correct?
Yeah, I think back then I played that game.
And that game was a war situation game where military armies would fight each other, yes?
I think so, yeah.
You also played a game called Every Man for Himself, or Last Man Standing.
Objection, Your Honor, to the relevance of this questioning.
Response?
Your Honor, this is merely evidence of a person's psychological trait, namely psychopathy. And under case law, the state v. Hamilton, any evidence of a person's psychological trait is not character evidence and is relevant.
Can I respond, Your Honor?
You may, once His Honor finds the right case. Yes, go ahead. Go ahead.
Evidence of the witness playing a video game while she was young does not fall under a psychological trait. Whether or not that evidence has been used to prove something else is an entirely different matter, but that would not meet that case law.
Your Honor, if you may respond.
Not yet, just a second.
Of course.
Objection is granted. Can continue to ask questions.
Permission to strike any testimony that may have, or motion to strike any testimony that may have been elicited?
Yeah, fine, stricken.
Yes, Your Honor.
Now, Jesse, I'd like to clarify two things to the jury. One, you presented false information to the investigating officer when you were being deposed.
I guess at first I was confused, so I may have said something wrong.
This was about both the length of the call to your mother after the incident and about whether or not it was yours or Sydney's idea to play with the gun.
Well, Yeah, it was just so long ago, I guess I only remembered a little bit of the phone call and what happened. It's just been a long time, so I was really confused. I guess that happened.
And I'd like to clarify one more thing. It was your idea to play with the gun on August 18th.
Objection, Your Honor, to cumulative.
Response?
This is not cumulative. This is merely entering in evidence that the jury's not been presented with the act.
Response, please.
Opposing counsel's previous statement was to elicit or whose idea it was to play with the gun, therefore this would be cumulative evidence.
I'm going to overrule. This is cross-examination. You can go ahead and ask a question, counsel.
I'll repeat the question. To clarify for the jury, it was your idea to play with the gun on August 18th, 2010.
Well, I guess so.
Thank you. No further questions at this time.
Thank you, counsel. Redirect.
There's no redirect necessary, Your Honor. I only ask that my witness be allowed to step down.
Yes, of course. Thank you for your testimony.